We have a motion that I need to address first, and that is a motion that was filed, I believe, yesterday, perhaps. Do you have that motion, please? This would be defendant filing number 74, a motion to continue the trial due to the recent CDC issued guidelines for protection from COVID-19 and the associated loss of expert mitigation testimony. So that is a motion, I believe, that the defense has filed just yesterday and it's been marked filed this morning. So if you would like to address that motion, please feel free.
Good morning, Your Honor. Thank you. So, on behalf of Mr. Wiggins, defense filing number 74,
Is there a reason that podium is turned in that direction? That may be for opening statements, if assuming that we go forward. But is it difficult for you to address that?
I don't have any issue.
I believe that's what's happened is that it was situated in such a way so that it could face the jury in the event we were to get to the opening statements part. So I'm sorry, Mr. Evans, please go ahead.
No, Your Honor, and I appreciate the consideration, but I think I can manage. So, yes, Your Honor, we filed this motion to continue. Unfortunately, we're in a situation where one of the key mitigation experts in this case, Dr. Aaron Bigler, has contacted me, and I've attached his letter to my motion, which I'm sure Your Honor has read, and indicated that he is unwilling to travel at this time based on the surge in cases due to the Delta variant. And he has an absolute concern for his own safety. He's 72 years old. He has asthma. His wife is immunocompromised. He cares for her as well, and she would have to travel with him. And he has indicated they are both fully vaccinated. This is not a situation where they're not vaccinated, but as Your Honor knows, from recent CDC guidelines and information being released in the scientific community, there has been a surge in breakthrough cases. And right now, the number of new cases, even in Dickson County, as I noted in the motion, are at a high level. And he's got an absolute concern for his safety. And I can't say that it's frustrating in trying to defend this case with all the other stresses and concerns that a lawyer has in this predicament, fighting for his client's life. It's concerning and frustrating on top of that when you have situations where you have key witnesses that for very legitimate reasons. Let
me ask you, I'm sorry for interrupting you, Mr. Evans, but, and I certainly read through your motion last night when I received a copy. This court has, since the onset of the pandemic, we obtained a Zoom permit from the Administrative Office of the Courts and have been conducting both civil and criminal proceedings via Zoom during the height of the pandemic. This is a case where this witness is a mitigation expert that would be testifying only if we get to the sentencing phase, correct?
That's correct.
And there's no right of confrontation issue about him being required to appear personally in court because he's you and your client's witness. What would be wrong with allowing him to testify via Zoom? We can arrange that. He can stay in his home as long as he has internet connection, or he can go anywhere he has internet connection. But we can have him broadcast on this large screen television to the jury, and he can testify about everything he has to say under oath on the record, as we've done in countless other Zoom hearings where witnesses have testified. We had another murder trial not too long ago in which one of the witnesses that in a pre-trial motion testified from California, and that was conducted appropriately and successfully. So I'm just wondering if that's not a solution to your problem as to that particular witness.
I appreciate the court's consideration and suggestion. My concern is I don't think it would be sufficient in this instance. If for Dr. Bigler, considering the stakes and the jury as the judges of the facts and their ability to listen to what he says, consider what he says, weigh what he says, and give it the appropriate weight. I believe it would be unduly prejudicial to Mr. Wiggins to have a witness not live. And again, this is new plowed ground. We haven't had this issue. And I understand the Supreme Court's ruling as it related to hearings and other hearings, but in the context of a death penalty case, where the deciding factor would determine whether that person lives or dies, Your Honor, I don't believe that a Zoom would be sufficient to adequately protect Mr. Wiggins' rights.
All right, thank you. Anything from the state?
Your Honor, the state has opposed every continuance that's been requested by the defense, and this is no exception. We oppose this continuance. We have guidelines and protocols in place to protect the spread of COVID-19, have successfully done so, have tried several murder cases this summer in this courtroom and downstairs. In this particular instance, this expert can be placed under some additional protocols to keep him safe from COVID. He can travel alone. He can start driving today and be here in time for the sentencing hearing. He can travel by himself. We can mitigate any exposure that he has to anyone else and return safely to Utah, where I do understand the concern for his wife. But as the expert said in his letter, he's been vaccinated. He can wear a mask. We can put a shield up. We can take so many precautions to allow him to testify that in this particular case, a further delay of justice would just again go against the constitutional rights of the victim and the victim's family. And we ask the court to deny the defendant's motion.
Let me first address the details of the motion itself. This is a motion that was filed with the court on August the 2nd, today's date, but it was actually, thanks to Mr. Evans's efforts, was emailed to all of the litigants and the court and the clerk yesterday on August the 1st. The details of that are that on July 27, 2021, the CDC issued new guidelines for protecting the health and safety of participants in large indoor gatherings, given the current state of the global SARS-CoV-2 pandemic. In light of the surge in current levels in the state of Tennessee and in Dickson County particularly, they're arguing that it is unsafe for us to try this case, and that as a result of that, one of the key witnesses, Dr. Aaron Bigler, PhD, a defense neuroimaging expert, has determined that traveling from his home in California to Tennessee and back for purposes of testifying poses unacceptable risk to the health and safety of his family, and he has accordingly declined to make the trip. This is, and also attached was a letter from Dr. Bigler, who basically substantiated those things that Mr. Evans and the defense put in their motion. To address first the issue regarding the CDC guidelines, we are operating under the orders and guidelines that have been given to us by the Supreme Court of the state of Tennessee. And after the CDC guidelines were issued, the Supreme Court's General Counsel, Rachel Harmon, issued us an email which basically indicated that the Supreme Court of the state was not going to require a mask mandate, but they were going to urge the courts to err on the side of caution and allow people, anyone that wants to wear a mask would be allowed to wear a mask. It is recommended under the CDC guidelines that anyone who is not vaccinated fully. This courtroom is set up in such a way that there's a limited number of people who can be allowed. We have allowed live streaming of these proceedings through local media or national media to allow individuals who might want to observe a public proceeding such as this to be given access to the proceedings so that they are not inclined to come and sit in the courtroom with other individuals. It is this court's opinion that anyone who's in the courtroom certainly should and could wear a mask if they choose to do so. Those people who are proceeding in the case as witnesses or as participants, the lawyers, are free to wear a mask if they wish to do so. I think the only difficulty would be if they are going to be addressing the court or addressing something that's got to be on the record. The difficulty is sometimes in understanding. The witnesses will not be allowed to wear a mask because this court is of the opinion that allowing a witness to wear a mask may be violative of the right of confrontation for a defendant to be able to see and hear his accusers. The jurors that are selected in this case will be allowed to wear a mask if they so choose. And under the circumstances, we have a small group of people who, may want to be in this courtroom, and that is their choice to do so. I urge everyone to adhere to the CDC guidelines, but as far as that basis for the continuance, the court is of the opinion that we can continue this trial and go forward with it and not be in a situation where we're having any sort of issues that unduly exposes anyone to a risk. The question of Dr. Bigler presents more of an interesting scenario. First of all, this motion was filed on August the 1st. I would just note, without casting any blame in the situation, that the CDC guidelines were issued July 27th. On that day, we were in Knoxville, Tennessee, selecting a jury and doing death penalty qualifications. On July 28th, we were in Knoxville, Tennessee, doing death penalty qualifications. We were there the 29th and on the 30th. And on the 30th, we began the actual final selection of the 16 people, which concluded sometime late Friday afternoon, and no issue was raised by the defense at that point regarding any of these matters and the CDC guidelines, even though they had been at that point out for 3 days prior to the final selection of our jurors. So I'm not, again, of the opinion that this presents the type of urgency that would justify a continuance in the case. And clearly we operated in Knoxville after those CDC guidelines, and both sides cooperated in selecting the final 16 jurors. As to Dr. Bigler, this court is of the opinion that Dr. Bigler is a defense witness for mitigation at the sentencing hearing. He does not go to the guilt or innocence phase, from what I'm told, and instead would be a witness that the defense might want to call. The defense is free to call any witnesses they want. It's their responsibility to ensure that the witnesses they choose are in court. It's not this court's requirement that I have to stop a trial just because a defense witness who may not be under subpoena is not able to be here. We can make accommodations for Dr. Bigler to testify via Zoom. We've done it in many other cases. We've done it in a huge number of civil cases. And frankly, my assistant, Ms. Fry, has gotten quite good at conducting Zoom hearings and Zoom proceedings. And as a result, this court is of the opinion that if Dr. Bigler wishes to testify, he can do so by Zoom, or he may not wish to testify by Zoom, and the defense may or may not choose to call him. But that it is not depriving the defense of an opportunity to present this evidence when we're offering an alternative, safe means for him to do so. I understand his concern. I understand certainly that he doesn't want to risk traveling to Tennessee, and I don't blame him if he has health concerns for himself and his wife. But as far as driving from here to California, I'm not sure that that's a viable option, but I think that presenting his testimony via Zoom, I would simply point out in response to the defendant's argument that the live testimony is more persuasive. There's a great deal of this testimony in this case that from pre-trial, not testimony, but evidence that is going to involve video evidence that's going to be presented on this screen. So presenting the defense expert witness testimony on that screen, in my opinion, is not unreasonable if in fact that's what they choose to do. So based upon all of those factors, this court is of the opinion that the motion to continue should be denied, and the case will go forward today. Now, a couple of things I'd like to touch on. We are working on our final draft of the charge, the initial charge of the court for the jurors. When the jurors arrive, we will bring them in and swear them in, and then I'll give them that initial charge. But I want to give both sides an opportunity to review the draft of my initial charge before I give it to them, to make sure that there's not any suggested changes or objections. So what I'm going to do at this point, since the jurors were not scheduled to arrive until 10, is to take a recess and go from there. I would just simply also observe that we have asked, and I think the state has asked, that the right side of the courtroom behind the district attorney's office be reserved for the family members of the victim in the case, and I believe that's been marked so appropriately. Anyone that sits on the left side, I think you wanted, I'm not sure if you wanted it, but if there's a need for you to have the front row behind you for any of your staff, then we'll make sure that that takes place. Beyond that, if there's any other people that want to see this, then they can do so by, if there's room, it'll be first come, first serve, and then beyond that, it'll be anyone that can watch outside on one of the TV screens, I assume we'll be broadcasting.
We did not know if you wanted that since witnesses will be out in the hallway area.
Well, probably, there's multiple opportunities for people to see this online without having to have it broadcast out. And I'm concerned about broadcasting the proceedings out in the foyer on those TVs because of that very thing, that there may be witnesses or other people who arrived that maybe haven't been put into that proceeding. So unless there's some reason to broadcast it on one of the televisions out there, I would avoid that. So.
Judge, it's hard for us to anticipate the number of people that will actually come to the courthouse to watch. So we're going to have all of our witnesses in rooms that do not have television access. Right now it looks like we have plenty of room inside the courtroom, but is there any way that one of the TVs outside the courtroom can be broadcasting in case we have overflow?
I can ask for Ms. Miller's laptop, and we should be able to set it up down in the jury assembly room, down on the first floor.
So if there's anyone who wants to watch the proceeding that's not a witness, they could go to the jury assembly room on the first floor, and it would be broadcast on the screen here, down there. We have a screen such as this in the jury assembly room on the first floor, so that anyone from the public who might want to watch and shows up, we could direct them there and have them watch the proceedings that are taking place here through that. Any objection to that from either side, as long as it's made clear that those are not witnesses but are just the public?
Yes, Your Honor, I have defense has no issue with that being, as long as it's a closed room. I would object to any of being displayed on any TV in any common area in the courthouse, because we're going to have witnesses coming in and out.
Well, and I think that's the wise thing to do, is let's use the jury assembly room on the first floor, and we'll set that up so that it can be broadcast. And that way, if we're going to limit the number of people that actually are coming into this courtroom, and obviously for space reasons, if no other reason. But beyond that, we will go ahead and set it up for anyone in the general public who wishes to do it. But we need to put a sign on the door that no witnesses are allowed to be in that jury assembly room during that broadcast. All right. All right. Anything else then I need to take up before we take a recess to work on the charge?
No, Your Honor, if we could have a brief in-chambers meeting regarding a couple of preliminary issues.
All right. Then let's go ahead and take our recess, and I'll meet with counsel in chambers to discuss anything that we need to talk about. So, stand at recess.
All rise. This court is in recess.